Good day, AP students. We have a couple of things that I need to teach you about in my virtual Mr. Barikmo version. I'm coming to you recorded from beautiful Hutchinson, Kansas. I mean, look at that hotel. Isn't that hotel amazing? That sunset is gorgeous. That was not the sunset last night, of course, but we have a couple of things that we need to get through. I've got to give you some information about civil rights and civil liberties, tie those intro pieces up, but then you're going to get to work. You have a project that I'm going to ask you to work on. Mr. Pittman's going to be coming in on Monday to help us out with this part of the project too, but you're going to help create some content. You're going to do what I'm doing right now with Microsoft Mix and PowerPoint to create some lessons and to create some content for all of us. So let's get to work. We'll review a little bit of what we talked about civil rights, and then I'll introduce civil liberties, and then I'll turn you over for your assignment. So the last time we were together, this was the last piece that we really ended up with, and it's a pretty straightforward summary of the history of the civil rights movement. The civil rights movement and the public policies that come out of the civil rights movement don't really have a context until we go back and look at and deal with the reality of slavery and the Civil War. Once Reconstruction starts to happen, many changes to the basic structures of society have to begin to change, and that becomes a challenge. And so you get courts that support institutionalized discrimination and violations of those civil rights in Plessy versus Ferguson, and then you start to see that really begin to whittle away, but in a big way go completely out the window with Brown versus Board of Education in 1954. When the court deems that segregation is inherently unconstitutional and overturns Plessy, it really moves the civil rights movement into high gear. So then we get to the Montgomery bus boycott and all the sit-ins and civil disobedience that we talked about. But ultimately, really what we're looking for is how does this social action translate into policy action? And the Civil Rights Act of 64, the Voting Rights Act of 65, and the Fair Housing Act of 68 really give us a great example of how that political movement, that social movement, that social justice movement translates itself into policy. So remember, Brown versus Board of Education was the unanimous court decision that overturned Plessy, and it says basically that segregation creates a psychological harm and on both black and white people. That goes to the psychological experiments conducted in the 40s and cited as evidence of this harm that is created by intentional segregation. And so that begins to really change the track when we look at civil rights legislation. Brown versus Board was not enough in 1954 because everybody was taking their time and realizing that this was going to take a long time to work through this desegregation process. So the family brought suit again, and the court heard the case the next year, 1955, and Linda Brown and family were able to get the court to say that you need to desegregate with all deliberate speed, and then they said we will use the enforcement powers to make sure you're actually desegregating. So the question then becomes, how do we deal with the realities of this economic and social segregation? Is desegregation of schools enough and desegregation of all of the facilities enough, or is integration really the key, and how do we make that integration happen? There's an interesting case in 1971 called Swan versus Charlotte Mecklenburg, which basically says we need to remedy this desegregation problem. It's not working. It's not happening with all deliberate speed. And so the remedy was include racial quotas and the number of people of color you have to have in your schools, not colleges, that's different yet, but racial quotas for elementary, middle, and high schools, redraw the district lines, and the court orders busing. So taking students of color into predominantly white schools and taking white students into predominantly schools of minorities in order to really force this integration. And a lot of the courts looked to the suburban schools that were more successful and largely white, and said, suburbs, you need now to give back, and you have to bus or allow the busing of students into your district in order to go to your school. In Milwaukee, where I grew up, I went to a school in Wauwatosa, Wisconsin, and we had something called Chapter 220. And Chapter 220 was a busing program where students from the city of Milwaukee were bused out to the suburbs in order to get the education and remedy the issues of segregation caused by hundreds of years of public policy. So just a little bit of review of the public policy aspect. The Civil Rights Act of '64 was put in place to prevent discrimination in public places. Couldn't discriminate on the basis of employment. The Equal Opportunity Employment Commission is set up, which is there to enforce the law, and it also then has the teeth in it are withholding federal grants from any institution that discriminates. And the Justice Department was the one in charge, the Attorney General was the one in charge of enforcing the policies. There's another type of discrimination, not just racial discrimination, but gender-based discrimination. Remember, we talked about the 5 protected classes. Race is a protected class, but so is gender. You cannot be discriminated on the basis of gender. This has what the court calls mid-level review. Race is strict scrutiny, which basically says if there is any sort of discrimination, we will stop it. Gender discrimination faces mid-level review. It's not as easy to reach the threshold of gender-based discrimination, but it's not strict scrutiny, but it's more like a reasonable person would be able to see and say that this is gender-based discrimination. Arbitrary differences are not allowed. So you can't just arbitrarily give somebody a job based on their gender. Gender-based differences, things like all-male draft or male locker room attendance or female locker room attendance, you can discriminate. Obviously, the all-male draft could change because women are allowed and are encouraged now to also be on the frontline combat positions. So maybe the court would say that the all-male draft is gender-based discrimination. I don't know. We'll see. A civil rights issue that is protected by the courts are victims of sexual harassment. And sexual harassment in the workplace or in education or anywhere is considered a civil rights violation. And there's a couple of different versions of sexual harassment that public policy puts in place. One's called quid pro quo, which is basically saying, hey, if you trade these sexual favors in order to hold your job or for a promotion, then that becomes a quid pro quo violation, and you have a lawsuit on your hands, a civil rights lawsuit. It doesn't have to be as direct. It could be a hostile work environment where harassment or the fear of going to work creates a problem in actually completing the jobs. In both cases, employers are liable. A quid pro quo, they're strictly liable. If it happens, they're liable. Hostile work environment, if they were negligent and they purposely created it or they knowingly created a hostile work environment, then they're liable in a civil rights lawsuit. One of the new areas of constitutional law is the role of sexual preference, sexual orientation in the Constitution, and this is a series of cases that has grown more and more important leading up to last year's decision, Obergefell versus Hodges, the famous gay marriage case, where the court said that gay marriage is a fundamental right. But if we go all the way back to Bowers versus Hardwick, you had laws in Georgia and across the United States that said the sexual activity that goes along with gay men, for example, is unconstitutional. They said it's unconstitutional, and the laws in Georgia were saying we can regulate this sexual behavior. And in 1986, the Supreme Court overturned that and said that, upheld that and said that it's not a fundamental right to engage in sexual relationships that are deemed non-traditional or non-conforming. In Romer versus Evans in 1996, the Colorado voters adopted an amendment saying that it was illegal to protect persons on the basis of gay, lesbian, or bisexual orientation. And the Supreme Court said, no, in fact, you cannot institutionalize discrimination. The famous Boy Scouts case in 2000 has Dale applying for a Scoutmaster position and was denied. And the court upholds the right of the Boy Scouts of America to free speech, and there's an equal protection issue. So they're saying in 2000 that Boy Scouts of America can discriminate against people based on their sexual orientation or sexual preference. Then we get to Lawrence versus Texas in 2003, which overturns a Texas law, much like Bowers versus Hardwick, banning sexual relationships. Lawrence versus Texas overturns the precedent set in Bowers versus Hardwick, and then that sets the case for gay marriage challenges, where in 2015 the Supreme Court said it is a fundamental right to marry, and enforces gay marriage into all of the states. Where civil rights gets controversial then is how do we begin to remedy this discrimination? One of the ideas, and still in place largely, put forth by Lyndon Johnson was the idea of affirmative action. And Lyndon Johnson said that equal opportunity is essential, but it's not enough. We can't just say we're going to give you an opportunity. We're going to make sure your opportunity is protected. But we have to seek, he said, legal equity and human ability and equality as a right. He said, but equality as a fact and equality as a result is harder to achieve. So we need to put some policies in place, and that's where we get things like affirmative action. He describes it another way. He said affirmative action is summed up very simply. You don't take a person who's been hobbled by chains and you liberate him. You bring him up to the starting line of the race and say, go ahead, compete. You have to do something to put into action a little bit of help. He said, it's not enough just to open the gates. We have to help all citizens walk through those gates. And this is where the controversy of affirmative action lies. And this is where the controversy of legal remedies and public policy to deal with segregation and civil rights violations becomes very controversial. Okay, so we've talked about civil rights, but we also need to talk about civil liberties. See, civil rights and civil liberties are taken together often because the court is required to interpret what exists in the legal protections and what doesn't. Civil rights and civil liberties, though, are differently defined. One is a positive right, one is a negative right. And so we need to look at that, and we need to kind of understand what that means. As you can see, civil rights and civil liberties are different. Civil rights are considered positive rights. They're the freedoms and protections that you have, that the Constitution needs to protect you with. The Constitution gives to you because of the virtue of the fact that you're a human being. Those are civil rights. Those are the protections you have. And the civil liberties are negative rights. They're the right that you have to not have the government involved, the freedom from government intervention. We see a lot of our civil liberties in our Bill of Rights. The Second Amendment is a civil liberty. The First Amendment free speech protection is a civil liberty. And the key distinction is the positive rights are the freedoms and protections that you have and you have been given, you already have as a virtue of the Constitution, and negative rights are those rights you have because the government can't intervene and can't take those away from you. So a great example of a civil liberty would be the freedom of religion. And if we look at what's protected by the freedom of religion, it says in the First Amendment that Congress shall make no law prohibiting the free exercise thereof. What we're talking about here is that the Congress, the government, cannot make any law then that infringes on your free practice of religion. You can practice the religion that you want to practice. You can believe what you want to believe. You can't be denied your civil liberty in school, for example. If you have a religious event that you need to be a part of, it can't be held against you academically. So that is a free exercise issue that we're talking about here. What we look at with this freedom of religion, though, is kind of where is that intersection of church and state? Where is that intersection where the state can get involved, but only to a certain degree, right? The freedom of religion is the first freedom that we look at in the Constitution, in the Bill of Rights. It's the first part. It's the first part of the First Amendment, and that's a key thing that we have to explore. An example of a really interesting case dealing with freedom of religion and the right to practice a religion freely and the intersection of church and state is a case that comes out in Florida in 1993, the Church of LUKUMI BABALU versus the city of HIALEAH. And essentially what happened here is you have an animist religion that earth, space, spirituality, involves animal sacrifice, different things like that. And they wanted to start a church in Hialeah, Florida. Well, the city council passed a regulation and a zoning regulation that said that they couldn't practice, that they couldn't have churches in this area. Well, that only applied to the Church of LUKUMI BABALU, and it was clearly discriminatory. And they said, we don't want this, we don't want animal sacrifice in our town. We don't want this, this crazy religion and this crazy religious practice in our town. So they tried to block them with city ordinance. And they said we have a compelling state interest in order to make this happen. And sometimes the court will allow the compelling state interest argument, but in this case they didn't, because in this case they were only discriminating against the Church of LUKUMI BABALU, and they were only discriminating against them because it was very different and they didn't want it. And so it did not pass the level of strict scrutiny that the court was trying to use. And the court then said, no, this is unconstitutional. You don't have a compelling state interest. And in fact, you need to allow, because you allow other religions the right to practice freely their religion, you need to allow this church as well. This is a fascinating case that looks at this, again, issue of civil liberties in our Constitution. Okay, so now your task. Your task is to take the constitutional case that you've been assigned, which is on the PDF on my website, and you're going to do some research. And you're going to create a PowerPoint that is at least 5 slides long. And looking at that case, you're going to answer the following questions in a PowerPoint for Monday. The key things that I need from you are, what are the constitutional questions in play in this case? What clauses or section of the Constitution applies here? What was the Supreme Court of the United States decision in the case, and what are the ramifications of the case? What are the effects? You're going to produce this PowerPoint, and you're going to produce this video that goes along with it, where you walk us through and you teach us this case. And so your task is outlined a little bit on the assignment. Your case has been assigned on the PDF on our website, and it's time to get to work. Go grab a laptop and get to work.